Hi friends, this is P.R. Krishnan. Welcome to my 15th and the last edition on RERA from my perspective. In this final video, I'll point out pointers or some practical situation or points that I have seen or feel one should keep in mind. I'll also touch on SRA development, some practical 3-4 points that I know of because SRA is a much more complicated case. Let us go to the slide. Practical points. If you are withdrawing, please ensure that a complaint is filed under section 18 and section 31. Please mention both the points, and complainant should quote both these sections for claiming compensation, because if you do not quote section 18, the builders can say that they have not quoted section 18, therefore you will not get the compensation part of it. Also, next point, before filing, please also ensure you first make a written complaint to refund the full amount with interest and compensation with the builder, because section 18 says promoter shall be liable on demand. If you don't demand, how do you know that he will not pay? So this question comes in, and it could also delay the process. So its best thing is to first make a claim and give him 15 days to respond, and after that you can file the complaint, and along with a copy of the demand letter. Next point what you should always look at is, please ensure that in the lower court the authority first hears the case. That is, the learned members should adjudge first with the interest and the refund. They should find out the cause, if the cause is correct or not. Basically there are two people, one is the learned members, the other is the adjudicating officer. Adjudicating officer is the district judge, and members need not be from the need not be a judge. Therefore people think judges are bigger and they bypass the member, which you should not do, because again the file will have to go back to them. The adjudicating officer can only look at issues which are concerning compensation and interest, which are compensatory in nature, okay, which are related to delays and other things, because he has to look at various factors. So all other things have to be looked at by the member authority. So first go to the member authority, have a full hearing, and let him transfer it to the adjudicating officer for compensation and for claiming under section 18. Okay. Now next point, where violation pertains to section 3 or 4, it should be filed only with the authority. So 3 and 4 has got nothing to do with LOT, is something default by the builder. Section 3 is basically if anybody, the builder, sells anything, any flat without first registering with the authority, so he is exceeding his limit. Section 4 is basically where he has to give all the documentation, and if he gives false document or doesn't give some documents, then that is section 4. So other than this section 12, 14, 18 and 19, any other section, if there is a complaint, it has to go to only the authority, member authority. Okay, only they have jurisdiction, not the AO. Now if you do not have any compensation as a claim, only authority can decide. Only if there is a compensation, it has to go to adjudicating officer. So if there is a compensation also, the adjudicating of the member authority will first hear it out, then he will transfer it to the adjudicating officer. Okay. Now let us look at the next point. Interest and compensation under section 12, 14, 18 and 19, we all just saw that, can be given to the LOT or the promoter. It's either way. While some realized by way of penalties which are imposed under section 76 is to be credited to the consolidated funds of India in the state. So only under section 12, 14, 18 and 19 are concerning between the builder and the LOT. All other sections where there is a default, the money will go to some other fund. Okay, you just need to keep yourself noted on this. Let's look at the miscellaneous points. Earlier consumers can only crypt, can do nothing. Now they need not do anything. It is given by the Act that builders will do it. Builders will have to do it now. If they are not following the law, then you can complain, or anyone can complain for that matter. Now this has also reduced the number of complaints, because builders have become aware and they have started giving the details and information. Now also the owners are shifted from allottees to builder now. Builders are responsible, accountable, and they have to give it on time. Instead of complaints on issue, now the complaints value has changed to it is based on non-compliance. Things have really changed, right? Now let's look at the next point. Now this is a slide basically dedicated to redevelopment, SRA and rehabilitation process or matters related to that. Now what are the points here? Builder registers only sale building because SRA building need not be registered. Only the sale part of the building should be registered. So that is permitted. But project gets stalled as sale building depends on SRA, and SRA there are many issues that I think all of you need to be very careful. In an SRA case, things don't work the way it happens because the sale building will have to be given only after SRA building is given possession, and under SRA there is always a fight. The builders change and you all get into a lot of quagmire and difficulties. So you need to be aware what is the status. Be careful while investing in an SRA sale building. Though now the sale building is also coming under RERA, there could be a lot of issues and delays. So it is a complicated one where builders also cannot be blamed, and the RERA is also trying to find solutions for this. Okay, so I do not know if they have found the solutions now. So be careful. Sometimes SRA changes the developer but in the sale building there are buyers who must have paid and therefore they are at risk. The new developer will change rules and may miss out people, or he may not even consider you. So be careful about that. This is just a suggested point. Now next suggestion is suggested no phasing of the project. As per law, the entire project of both SRA and sale will be one project. Developer cannot break. So this was a suggestion, but I think it is getting into difficult situations, so update we need to have on this. Under development, also delay in giving possession, changing layouts and plans, not giving rent even when delayed or when it is under redevelopment, work not progressing, poor construction quality, not obtaining OC, not convincing. There are number of issues in redevelopment. Okay, redevelopment is that they'll have to be given the house first and then the sale component. So in redevelopment also there are number of issues that keep coming up. So be aware of these conditions. Be wise while taking decision to invest in such your hard-earned money in such flats. While this will be the last slide, I am just wanting to tell you to also study one case, which is Neil Kamal Realtors versus Suburban versus Union of India. In this case, many developers had filed a case together. They challenged the RERA Act because they didn't want to follow the RERA Act. Okay, their liberties were getting eroded. What they wanted to hide from people, they are all getting exposed. So everybody started filing cases against this section, that section, every section, literally most of the section. Therefore, in this case, it was a landmark judgment of some 140, 145, 142 pages actually, where the judge also took the support of amicus curiae, that is basically the friend of the court, and each case, each point was decided very beautifully. They took out various case laws to point out each of the points, each of the sections. So it is a session by itself, but I suggest you go through this case. It is very helpful and you will understand better. Friends, this is the last video on RERA. With this, I think I have covered almost everything. All the important points. I am sure this video would have been liked by you, all the videos, and it has given at least a lot of information and knowledge on the subject, and many of your doubts, queries, etc. you would have got clarity. I am sure between when we started this and now, you have gained a lot on the subject and what the Act actually provides for and how different it is from the erstwhile MOFA. To summarize now, we have covered the following heads: important points, sections of the RERA Act, rules, background and objectives, the landmark of this new legislation, the main features, various important definitions, process of registration by builders, their importance, interest in great detail under compensation, adjudication and separately also being most important, compensation and its process, adherence to the sanctioned laws, plans, title defect with lifelong liability on builder, offences and the various penalties, revocation of registration and what happens thereafter, how your funds are safe, agreement, possession date, unit of measurement, society formation and conveyancing, and your right to non-compliance when it is, recall important CA sections and some new sections we learned also, recall the earlier discussed features and a few new features that was not discussed earlier, and some general points. Okay, whatever practical points I knew I have also discussed. And before I conclude, I just want to thank you. If you have any doubt, please do not hesitate to contact me, and whatever is within my capacity and understanding, I will try to clarify your doubts. My mail ID is advkrishnanpr@gmail.com, and you may send in your queries. I will try to respond as quickly as possible. Okay. Finally, before we leave, please do not forget to leave a comment, and if you have liked the video, do subscribe for it. Please also share with other groups so people benefit with the knowledge they can get from this. So with this I conclude here. Thank you all for watching all the videos. Thank you so much.